Okay, this is Grow Michigan LLC versus GSE IAS LLC et al., docket number 20-469CB, and this is the time set for hearing on the plaintiff's emergency motion to direct interpleader. This will be challenging, but can we start with appearances for the record, please, starting with the plaintiff?
Good afternoon, Your Honor. Bill Burdett on behalf of Grow Michigan.
Okay, and then, oh, wait a minute, someone else is phoning in.
Might be my client representative, Henry Brennan.
Fine.
That is actually his phone number.
Yes.
Okay, so I'll go through this to prevent everyone from talking at once. Then, who's appearing on behalf of GSE Machining? Nobody?
Mr. Wardrop, Your Honor, his name appeared on the screen earlier, but now it no longer does. But he filed a response for machine. So
Yeah, I saw his name pop up, and now for some reason it's disappeared.
Mr. Wardrop did appear for machining.
Okay, well, let's go through the appearances and give him a chance. Maybe he got disconnected or something. So for Affling Corporation?
George Brookover on behalf of Alfing Corporation, Your Honor.
Thank you. For GSE IAS?
Michael Perry at Fraser Trebilcock with Amy Mullanen for GSE IAS, Your Honor.
And for MSU FCU?
Scott Chernich, Your Honor, on behalf of MSU FCU.
Okay, I can barely hear you, Mr. Chernich.
Sorry, is that better?
Yeah.
Okay. Scott Chernich
Okay.
on behalf of MSU FCU.
Okay, and Mr. Wardrop, for some reason we lost you, so we were just going through appearances, and you represent GSE Machining, correct?
Yes, Your Honor.
Okay, did I get everybody? All right, then this is plaintiff's emergency motion to direct interpleader, and Mr. Burdett, if you're ready, you can go ahead.
Thank you, Your Honor. I represent Grow Michigan, which is a mezzanine finance lender that lent money to GSE Machining, which we refer to in our motion as old GSE and complaint as old GSE. And that was an entity that was engaged in machining products and was pursuing, in our verified complaint, we lay out the fact that old GSE was pursuing work from Alfing Corporation. And that, as late as last year, before new GSE was created, which is the GSE IAS. This is an awfully unique situation because we have a security interest in what's called the general intangibles, those things, the know-how, the aspects of old GSE that allow someone to do exactly what's happened here, apparently, which is set up a subsequent entity to try and avoid paying the debt that's due to Grow Michigan, and that Grow Michigan had a secured interest in the collateral of those general intangibles, including something like pursuing the business of Alfing. Mr. Wardrop's response on behalf of old GSE, while lacking any sworn statements in support of that, did indicate that this new GSE is set up by the wife of the principal of old GSE. And as Exhibit E, I believe, to the verified complaint indicates, old GSE or new GSE is doing business out of the facility that housed old GSE and is, sending all of the accounting, is being handled out of the house of the executive of old GSE because, lo and behold, his wife set up the business of new GSE. And so, we think that there are, and these are facts that are undenied by any of the various pleadings that were filed in this case. And so our position is that this is something that should be these funds that were sent to MSU FCU and being held by MSU FCU should be at least placed in interpleader. Grow Michigan would argues that under our security agreement or intercreditor agreement with MSU FCU, then MSU FCU has an obligation to send those funds to us. Alfing, of course, takes the position that MSU FCU needs to send that money back to Alfing. so that it can pay this new GSE entity at the same address as the old GSE entity. And so what all we asked to do is for this court to exercise its equitable powers and direct that the money be deposited with the court and held, and that would be through the interpleader rule. And the important thing to point out here is that this isn't trying to attach anything. This is merely saying that under the court rules, and specifically 3.603A2, a defendant such as MSU FCU, has the opportunity to place monies in interpleader. When I spoke with Mr. Chernich at MSU FCU, he indicated that MSU FCU wasn't going to return the money without a court order, but it didn't feel the need to pursue filing an action with regard to this money. Given the rules of equity that govern interpleader, even with the court rule that has been issued, we have a defendant, a financial institution that has money that says it's not ours. And we have two entities, Grow Michigan on the one hand, that believes it has a security interest, and that security interest is indisputed by any of the other pleadings that were filed in monies that were generated from the collateral of old GSE. And we believe, and we think that the verified complaint lays out enough facts to justify at least holding on to the money until it is deposit, and with the court, until we can resolve this and not return that money. And so, these facts, so we would ask this court, based on its equitable power and the reading of 3.603A2, to direct MSU FCU to interplead the money to the court. The court holds on to that money until such time as this dispute can be resolved. It is interesting that there were all of the pleadings that were filed didn't attach anything that denied any of the facts that were in the verified complaint, didn't give anyone a sworn statement that says, hey, this is they're wrong here. They only said, look, they're different companies. But then the facts that are undenied are that the different company was set up by the wife of the former executive, that the different company, or that the old company that was run by the former executive was pursuing business with Alfing, that mysteriously is now being done by this new company, new GSE, and that new GSE couldn't have pursued this work without the general intangibles of old GSE. This may be subject to proof, but Grow Michigan believes that the only way that its security interest in the collateral of old GSE can be preserved and given any value is that this money should be held until such time as this dispute can be resolved. Because our fear is that if new GSE can be set up by the wife of the former executive, that we're going to have to chase this money time and time again until it is firmly in Grow Michigan's hands. The interpleader rules do exist in order to stop that sort of dispute and say, well, let's figure out where it goes before then making one party or the other have to chase after it, or exposing MSU FCU to unnecessary liability. Because if MSU FCU returns this money to Alfing, Grow Michigan will pursue a breach of contract claim against MSU FCU. Similarly, I would expect Alfing has made other sorts of statements with regard to MSU FCU with regard to the return of the money. Now, Alfing may claim that this money needs to be returned. There's been some reference to the fact that it needs to be returned before GSE IAS needs, this new GSE entity needs to return or provide whatever goods that are being paid for under this invoice. But I'm certain that there are ways to work around that, or to say, well, once if this is all really true, then you'll have your money. But in the short run, we better make sure, in order to provide some value to the Uniform Commercial Code and parties with secured interests in collateral.
All right, thank you. Mr. Wardrobe, do you want to go next? You're muted.
You're muted, Rob.
Sorry, Your Honor, I had on mute. I'd prefer to go after Mr. Perry. We really don't have a dog in the fight. If
Okay.
that's okay.
I just had you written down next, so, Mr.
Thank you.
Perry?
Yes, Your Honor, thank you. Your Honor, the interpleader court rule does not apply to the facts alleged by plaintiff. Plaintiff does not hold an asset which two or more parties are claiming. The plaintiff wants the court to order another party to begin an interpleader action. Plaintiff has absolutely no legal authority for this request for relief and has, this afternoon, failed to give the court any authority for this relief. So fundamentally, just from the outset, looking at the plaintiff's own pleadings, there is no factual basis to support a claim under the interpleader court rule. Plaintiff lacks possession of the asset. Plaintiff has failed to claim that two or more parties are claiming the asset. My client is not claiming the asset. Old GSE is not claiming the asset. And MSU FCU is not claiming the asset. We understand from the pleadings, again, submitted by a verified complaint. Plaintiff itself says, MSU says, it's not our money and we should give it back to the owner of the money, which is Alfing. And there's no factual dispute. This is Alfing's money. Alfing should get its money. But our brief, which I'm sure the court is familiar with, addressed the legal deficiencies in the plaintiff's claim. And we would ask the court to find that plaintiff essentially has failed to state a claim. I know that that would be a summary disposition and they're entitled to 3 weeks notice and all that sort of thing. But it is so clear on the face of plaintiff's verified complaint, it lacks a factual predicate for this action. Plaintiff said something interesting today, that its claims, quote, if I'm remembering correctly, and it was just said a few minutes ago, so I think I do, said, quote, it may be subject to proof, end quote. Well, it's not maybe, it is subject to proof, and they have no proof. And so we would ask the court, for the reasons stated in our brief, as well as for the utter failure of any proof by plaintiff, to deny this motion. And I'd be glad to take any questions the court may have.
I don't have any. Do you want to go next, Mr. Wardrop, now?
Yes, Your Honor. Your Honor, we may have caused more trouble than we helped Mr. Perry in this matter, but we felt, given the complaint and how we thought it was a mischaracterization of the facts, we filed the response we did. I think it's interesting that basically the sole argument is the wife couldn't set up her own company. She did. We told them that a year ago that she was doing it. We told them exactly what they were doing. It is a separate company. She hired a very good law firm to represent her to do it right. She did it right. There's no proof at all that these are the same companies, and it wouldn't matter. This is not an interpleader action. Mr. Chernich's client hasn't asked to interplead the money. It has the money. We think, for the reasons stated by Mr. Perry, the court cannot grant the relief.
All right, thank you. Mr. Brookover?
Well, Your Honor, it's my client's money and we'd like our money back. I'm sort of reminded of the Dusty Springfield song, A Wishin' and a Hopin'. So when Mr. Burdett lays out what he claims is his argument, I'm reminded of that song because, as Mr. Perry has said, and I think we said similar things in our response, the court rule doesn't support the relief requested, much less an emergency motion. The complaint states no cause of action against my client. Frankly, I don't even know why we're here, other than it's a wonderful experience to be with all these very erudite attorneys who know more about all this stuff than I do. But the reality is, the so-called verified complaint in and of itself, as we pointed out in our filing, indicates that the plaintiff acknowledges that MSU Federal Credit Union doesn't feel like it has title to the money and that it should come back to us. So as far as I can tell, unless I'm misunderstanding something, everybody in front of the court right now acknowledges that it's my client's money. And given that fact, and given the paucity of either law under the court rule, which is in opposite to the claim that's being made here, or any case law, we'd simply ask that the emergency motion be dismissed with prejudice, and that the court, in addition, order that the funds be directed back to my client. Thank you for your time today, Your Honor.
Thank you. Mr. Chernich, I didn't see a written response from you. Did you wish to be heard?
Yes, Your Honor. Thank you. I didn't file a written response because in sum, MSU Federal Credit Union doesn't object to the requested relief. We're the proverbial rock in a hard place here. We've got competing interests that say they own the money or have an interest in it. We don't know which way to turn in terms of either one, because as Mr. Burdett indicated, whichever way we turn, somebody's going to have a complaint. So we're all in favor of turning the money over to the court if the court so desires.
Okay, Mr. Burdett, that covers everybody, right? Did you want any rebuttal time?
Pardon me, Your Honor, I had my mute button on. I would like a brief rebuttal with your court's pleasure, please.
Sure.
Thank you, Your Honor. I would point out that the legal authority that Mr. Perry insists was not cited actually was in our motion. We look to the fact that interpleader has long been an equitable relief, something that has to be fashioned to unique circumstances. This is a circumstance that Grow Michigan, it has been seen before. Even if we were told that Mrs. Emfield was setting up a separate corporation, Grow Michigan was never told that she was setting up a separate corporation for the purpose of doing the same business that her husband's company had been doing and pursuing that just without an obligation to pay the debts. MSU FCU is in a hard position. They said, well, we can't justify filing anything or doing anything here, but the fact of the matter is they don't disagree with the relief sought because there are two people here. There's Alfing that says they get the money back, and there's Grow Michigan that says, wait, nope, that's our money, MSU FCU. And to properly insulate MSU FCU equitably, who's got the money, and I'll admit that Grow Michigan does not have the money, but the fact is that they MSU FCU would be facing liability but for the interpleader rules and the operation of the interpleader rules. And we believe that this is a circumstance where the interpleader action should be modified to allow for us to request not that you direct the money to us, but simply say, let's hold on, let's put a pin in it, let's deposit with the court, and then let's see what the actual proofs are. Because at no point do we acknowledge that there is no proof. For an interpleader, the only proof necessary is that there are two people that say there's money that's owed to us, and one person saying, well, I've got it and I face liability of both of if I send the money one way or the other. That's the proof necessary for an interpleader. After that, we need to then determine who's actually entitled to it, and that will be subject to proof. And I believe that Grow Michigan's verified complaint laid out that proof. We have a company that's doing the exact same thing with virtually the same name and sending the money to the house of the former executive, where his wife actually presumably lives too, and then saying, well, I'm sorry, we're not the same company. It certainly looks and smells like an alter ego case, and we think that we have a right to pursue that and shouldn't have to then pursue the money after we preserve this, because we've got a secured interest in these general intangibles, and we firmly believe that those general intangibles were what was used in order to get this money paid from Alfing.
All right, thank you. Well, the purpose of the interpleader rule is to protect a person who's holding funds from double liability in situations where there's more than one person who claims a right to those funds. I mean, I always think of it in the simplest terms. The plaintiff who's bringing the interpleader is essentially saying, I hold these funds, I acknowledge that the funds aren't mine, and they have to be paid to someone, I just don't know who. And that sounds like what MSU is saying, but the difficulty here is that MSU is not seeking interpleader. This is the plaintiff's motion to direct interpleader. And I know of there's nothing in the court rule, and there's no law that's presented to the court that would say that you can make some kind of involuntary interpleader. So, you know, MSU fits, but they haven't requested it. And to the contrary, law has been presented to the court that it is the person seeking interpleader has to be holding the funds. And in fact, again, that's what interpleader is all about. The person holding the funds can sometimes actually be discharged from liability, and it's left to the court to decide which of two claimants is entitled to the funds, and I've done that before. But all of the factors that go with interpleader, not one of them is present here when you look at it from the perspective of this is the plaintiff, Grow Michigan, who is seeking interpleader. The plaintiff isn't holding any of the funds. And that is the law that's been provided to the court that I think governs, and that is that the person seeking it has to be holding the funds. The plaintiff isn't acknowledging that the funds don't belong to it, just the opposite is true. And the plaintiff is not in a position of merely needing to protect itself from double liability by having the court ultimately determine who, between two or possibly, in some cases, I guess even more, competing claimants should receive the funds. So it's very nice that MSU FCU doesn't mind if the funds are paid into the court, but I think I need to see interpleader action by MSU FCU in order to meet the legal requirements of interpleader. At this point, the funds, if anything, are more the subject of counts 2 through 13 of the complaint. And to order them at the plaintiff's request to be paid into the court as an interpleader would be basically a prejudgment attachment, because it would, that would, the only role that those funds could play would be if the plaintiff were to prevail on counts 2 through 13, that this is an alter ego situation, et cetera, et cetera. So I have to deny Grow Michigan's request to motion to direct interpleader because the plaintiff does not meet the requirements of interpleader under the court rule or under the case law.
Your Honor?
So, yes?
Your Honor, I was going to suggest, I submitted this Mike Perry for GSEIS. Yesterday, I sent in a proposed order, and I'd asked the court to sign it with an additional caveat that directs MSU FCU to immediately transmit the money to Alfie.
Your Honor, we would object to that additional caveat. That's not a subject of any motion. There's no indication that MSU FCU is under any liability to, like that, someone could say MSU FCU, you absolutely have to give that money away. That's going to be up to MSU FCU. And at this point, the only thing that we would ask the court enter an order that simply says the motion is denied, and that MSU FCU then has to make decisions based on the denial of that motion. But there isn't any entitlement for ALFing or GSEIAS. It's interesting that Mr. Perry would say that, given that he indicated that GSEIAS is not claiming the money held by MSU FCU. So, we would just ask you not to include any language like that, and that MSU FCU then has some decisions to make outside of the court.
I agree with you, and I've signed the order, which doesn't have anything in there about MSU FCU. It just says that the motion to direct interpleader is denied for the reasons stated on the record, and I've signed that order. which was the only thing before the court today.
Thank you, Your Honor.
Thanks for your time today, Your Honor.
Thank you, Your Honor.
That'll conclude our hearing.